One key right under the statute is the right of employees to designate a union as their exclusive bargaining representative to make demands on the employer to negotiate over and on their behalf about their working conditions. And the law imposes on the employer the obligation to actually negotiate with that union if the union has been able to establish that it represents a majority of employees in a defined bargaining unit. No requirement that the parties actually reach an agreement, but they do have to, by statute, make every earnest effort to do so, engage in good faith bargaining, and if they do reach an agreement, and in most cases they do, despite what you see about work stoppages and lockouts and things like that, the media always seems to be interested in. Most of the time there's an agreement reached, and when that happens, the law also puts the obligation on the parties to reduce that agreement to a writing if either side demands it, and to sign it. So those are, in a nutshell, the summary of rights and obligations under the National Labor Relations Act. The board is the primary, it's the federal agency that has the primary responsibility for enforcing the act in the first instance. The board is comprised of 5 members. They're appointed by the president. They serve 5-year terms. They're staggered terms, which means that every year there's going to, at least in theory, be at least one new board member to replace someone whose term is expiring. And the board also has what's called the Office of the General Counsel. General Counsel is responsible for deciding what kinds of cases are going to be prosecuted as alleged violations under the National Labor Relations Act. Those cases are tried before an administrative law judge usually, and they're subject to review by the National Labor Relations Board.